in any way disturbing those who have already been counselled, etc., which I would be entitled to ask for, but I don't want to ask for that. Let's not disturb what's already happened. If you've counselled 90% of them, you have 278 present. We are just seeking implementation of your Lordship's order. I have copies of a list which shows how your Lordship's clarificatory order posts that these have been implemented in the other states of the country. Just give the other side. Give me. We've just done a little bit of a deep dive to find out what the other states have done. So, post your Lordship's order of 10th December 25th, Punjab has implemented on 2nd January and then again on 4th February. West Bengal has required an order from the High Court 13th January. That's one individual, West Bengal. Bihar has done it on 7th February, and this order also your Lordship saw. Jharkhand is 10th February, Chhattisgarh 12th February. The KVs have done it on 13th February. NCT has issued a letter also on 27th January. Now, in this light, I believe that the same order should be passed where we can be accommodated, because that's the reason. And we are the same petitioners who came before you in that review. Same people who have got the benefit of that. Now, at the very least, that should be implemented by the state. I don't know why they're dragging their feet on it.
Yes, madam.
My lords, I mean, I did not have the benefit of appearing before my lords when the parent judgment and the review order was passed. But my lords, what is being sought right now is a clarification as to interpretation for the review order.
No, they are only seeking the implementation of our review order, which we have clarified by the review order. We did not enter in the review, but we clarified our order.
To the extent, my lords, may kindly see the review order and rather enlighten us as to what will be the interpretation, my lords, because the state will be is in compliance of the parent judgment. Who are the which basically upholds my service rules. My service rules are in consonance with the guidelines.
Therefore, we held that the special scheme was in order to protect those persons who were already in service on such and such date.
My lords,
I still maybe distinctly recollect the judgment. The correspondence between the Government of India and the various authorities, the NIOS and all that, was to provide avenue to those persons who are already in employment, so that they are not thrown away. And they had to complete the 18-month course online and all that. So if these persons were already in employment on 2007, then our clarification will come to their benefit.
Clarification, if my lords could kindly see paragraph 3, which is the cause of concern. If my lords could please see paragraph 3.
And you did not have, maybe you did not have the benefit, but Mr. Sethi had the benefit of arguing that matter.
My lords, the matter now, I'm the,
yes, so,
I've been the matters, I may not be able to give assistance.
Yes, we upheld his arguments.
My lords, may kindly see
paragraph 3.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. So the purpose, my lords, my limited understanding is that it had to be for institutions or for promotional avenues. At the same point in time, by the parent judgment, my lords upheld the rules as well.
So therefore,
my lords, the new fresh counselling has happened as per the rules.
So therefore, if there are any vacancies to be filled by the state government, and they are already working in some institution on a cut-off date, then they are intensively considered for migration from one institute to another institute, or if they are in the state government for the purpose of promotional benefit. And if you have 278 vacancies, what is the harm in not considering them? We don't say that you appoint them. Consider them their claim.
None of the individuals up till now, we have received any submissions with respect to what already there that any individual was removed from service or denied promotion as a direct consequence of the parent judgment. Please see my rules, my lords. My rules have been upheld. My lords, please see paragraph 15, my counter affidavit, and see the rules.
Madam, we have upheld, but at the same time, we are also clarified that all those persons who were in employment as on 10th of August 2017 will be considered as having an eligible diploma completed 18 months for all purposes.
Manoj, for the purpose, that's what I seek Manoj's clarification, since it said promotional avenues, which basically would have meant that in the
In
second.
other institutions would also include the government.
Manoj, may kindly see my limited submission. Would it also mean for the Uttarakhand government?
Yes.
That Manoj, may kindly see. As I said, my lords, the judgment was passed by my lords, and I will be just seeking my lords. Rather, it's the other way around. I am seeking my lords' assistance. Manoj, may kindly see my
Okay,
counter
then,
affidavit.
we will provide you the necessary assistance.
My lords, guidance, a better word. My lords, what? My lords, paragraph 14 and 15
Paragraph
of my counter affidavit. My lords, just
By your
see the
presence.
predicament. My lords, just see the predicament.
We are not directing you to appoint them. We are only directing you to consider their claim.
My lords, which would tantamount to what all the process that has happened up till the counselling.
We are not touching that counseling process.
He has been very clear on that. He has himself said limited to the vacancies which are left out now.
So, my lords, in which case, all I'm left with is passing of issuance of joining letters.
No, them counseling you.
My lords, merit list would go.
We are not, madam. You should have been attentive to what they said. Mr. Shankar Narayan was candid enough to say that he doesn't want to disturb the process which has already been completed.
I could see, my lords, but my instructions are this, that if you're going to consider and open it for these candidates that my learned senior is appearing for, it would have an impact on the list that has been prepared and the counsellings that have.
When he is also requesting that there should not be impact, and when we clarify that there won't be an impact on the selection already done.
My lords, the process, if my limited understanding would be that if there are X number of candidates and the Y are being added to the pool, the list will have to be looked into.
Even if you clarify it under 142, it will not a binding on it.
Very well, my lords. Very well.
Why I don't know what has happened to the state of Uttarakhand today.
My lords, may I clarify, my lords. My lords, I'm just.
We'll have to pass a cumulative order inviting your chief secretary.
My lords, that may be not needed. If my lords may kindly consider.
He has been candid enough. Still, you are saying you will have to disturb the selection already done.
My lords, I'm just trying to perhaps buttress my case with respect to the technicalities. However, if my lords are clarifying in order.
Just to help Ms. Shukla, there is no examination, etc. It's just that if you are eligible, you come. Now, if they've had a question of a glut of applicants, then there may be some issue they face. At the moment, there are 278 vacancies. We are 239. Ms. Shukla is right. They will have to open the door and just appoint us. That's exactly what will take place. But these are the applicants we were lordship just seeking enforcement of your
No, appoint us if you are otherwise eligible. Otherwise eligible, and we don't know. They might be having an interview process.
If you're not eligible, then the question doesn't arise.
That's right. That's what it is.
The applicants have approached this court for a direction to permit the applicants for holding the 18-month D.ED qualification, the D.EL.ED qualification from NIOS under the online diploma. What is the line? ODL.
DEL.
Online distance learning.
Open distance learning.
Open distance learning.
Open distance.
Learning more. To participate in the counseling process and for appointing to the vacant post in the ongoing recruitment. Paragraph. The case of the checkered history. Paragraph. What is the date of our judgment?
Original judgment is 28/11/23, clarified on 10/12/24.
Why our judgment and order dated 20th of November 2023. We had upheld the rules framed by the Uttarakhand government, which provided that for being eligible, we appointed as teachers. It was necessary to have a diploma course of 2 years
Or equivalent.
or
So the question also.
or equivalent course. However, in the judgment itself, we had clarified that the scheme was initiated by the Union of India for providing we had clarified that the scheme which was run by Union of India was done in order to provide one-time opportunity to such of the teachers who were already in employment on 10th of August 2017 to get a qualification of a diploma course. Most of them. We are also held that the deadline of 18 months, the diploma, a period of 18 months was specified in order to meet the deadline of appointing the teachers under the Right to Education Act, so and so. Correct. It appears that there was some confusion in some states, and therefore review applications were filed. We declined to entertain the review application on the ground that the judgment was clear enough, and it held that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10th of August 2017. We further clarified as para 3 and 4. Paragraph. The grievance of the petitioner is that though they have been, though they are eligible as per the original judgment of this court dated 20th of November 2023 and the clarification dated 10th of December 2024, in as much as the advertisement is dated
29th May 2024.
29th May 2024. That is, after the judgment was delivered on 20th of November 2023, the state is not considering their claim. It is submitted that in the reply given by the state government, it is stated that the selection process is already complete and therefore the claim of the petitioner cannot be considered. Sri Narayan further submits that. Shankar Narayan further submits that the information received under the Right to Information Act would reveal that there are 278 posts vacant and the number of applicants is 265. 39. Correct. 3. Shankar Narayan fairly states that the applicants do not intend to effect the selection process already done. Correct. Ms. Vanshaja Shukla, the learned counsel appearing on behalf of the state, on the contrary, submits that while the judgment dated 20th of November 2023, this court had upheld the rules of Uttarakhand state, which provided that the 2 years qualification was 2 years, the diploma in education of 2 years duration was necessary for being appointed as teachers. He further submitted that any interference at this stage would cause the complications in the selection process already done. Correct. No doubt that we have upheld the rules framed by the state government while our judgment dated 20th of November 2023. However, at the same time, we had clarified that such of the teachers who are already in employment on 10th of August 2017 would be entitled to the benefit of one-time scheme floated by the Union of India. And if they had completed, we are held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Very good. undisputedly other institutions would also include the schools run by the state government. Also, paragraph. We find that the case of the present applicant would be considered by, would be covered by our clarification dated 10th of December 2024. Paragraph. We therefore direct the state government to consider the claims of the applicants in accordance with our judgment and order dated, in our clarification dated 10th of December 2024. And if the petitioners are found to be eligible, the applicants are found to be eligible to appoint them in accordance with law. Paragraph. We further clarify that while doing so, the state should not reopen the selection already done and which have reached finality.
My lords, also, if the contempt will not be pressed because now placing them, my lords, if Mr.
So you can dispose of them. No.
Submission.
No, these are transfer applications. So now, in view,
We haven't filed any contempt.
Then I'm instructed, maybe not as a matter, but there are contempts by identical situated individuals.
That's a different.
My lords, if at all, then in that case,
But
for
these
the
so this is a transfer application. So transfer is sort of what a writ petition.
Yes, none of us have.
So you can now withdraw the writ petition itself in view of the.
The lordship can treat the transfer petition at disclose.
Yeah.
The main transfer petition can be.
Yeah.
But this can be made time bound.
The same shall be done within a period of 3 months from today.
My lords, a
Paragraph.
little more time, my lords, may be granted because, my lords, finally, my lords.
I was asking for a little less.
My lords,
The session will start, the children have to study.
my
The
lords.
new academic year.
The
If we
it is better
invite your chief secretary on 19th, it will be done within 15 days.
My lords,
If you want that, we'll do it.
my lords, I would not be able to speak.
It's only with an intention to extradite the whole thing, that's what it is.
Paragraph. So to उसमें ये लेना transfer application is also taken on board. Paragraph. In view of the aforesaid order, no orders are necessary to be passed in the transfer petition. Paragraph. We further find that the grievance of the petitioner would stand, the grievance of the petitioner as raised in the writ petition would stand satisfied with aforesaid observation, and the writ petitions also stand disposed of in terms of the aforesaid order. So there is no question of contempt.
Mr. Kalra is appearing before this High Court as well. That's what I'm saying, and you've made that submission in the other matters also. We will comply with them if I needed it. Let's go to Mr. Kalra. Great.
What is this other shift?
It's similar. The only difference is coming from Bengal, where there was a judgment of the High Court against which we filed the SLP. The High Court judgment came prior to your Lordship's clarification, but after the advertisement. So the High Court judgment effectively followed what was the main judgment without the clarification, thereby shutting us out. We filed an application, which is 19548 of 24. It's part of the SLP itself on behalf of, sorry, 199,548. I'm referring to 43.1. 43.1.
43.1 then, no?
43 is a transfer petition that's dealing with UP Bihar. 43.1 is the Bengal SLP. And yes, there are companion SLPs as well.
43.1, page number?
43.1, if you not have the paper. The recruitment notice is dated 29th September 2022. And that notice, in this case, included us, included D.EL.ED 18 months. Therefore, we were eligible, we applied, we participated. The challenge to that notification was taken by those who were the D.EL.ED 24 months, saying that we shouldn't be permitted to participate at all in the process. That writ petition first went to the single judge, and the judgment was passed on 29th February 24, allowing their writ petitions against us. Went to DB, impugn judgments 24th July 24, sustaining the
So
single.
they had taken a view contrary to the view taken by the Uttarakhand High Court.
Yes, they had. So they had gone with the point that there is equivalence effectively. Therefore, we are permitted to participate in that process. But the single judge and division bench concurrently said, no, we are not permitted. Now, in view of the clarification, all of us are, in my SLP, there are 388 in the SLP and 240 in impeachment. I think Ms. Makija is representing a larger number.
All in all, it would be about 600 odd, 650 or something like that. And there are 2,200 vacancies as of now.
We are totally 1,024 from what I understand, all of us put together, Mr. Prasad, Cindy, all of us put together. So we are seeking, Malons, similarly, that because in both Bihar, that clarification has been understood properly. Today, Your Lordship have clarified it for Uttarakhand, and Mr. Gupta's assistance was there before this court on that date when Your Lordships rendered the clarification of 10th December. I don't think there should be any cavil with this issue that we should be eligible and permitted to take part in the counselling. Now, the ones, and we have taken part in the counselling. Our name doesn't feature finally in the select list, but our name should feature in the select list because we were completely eligible. The only question was eligibility, which we had. That's really the only issue that I actually saw.
The ACD has also issued a clarification with regard to all the states.
Yes, NCT was supporting you.
In fact, NCT brought along the scheme with regard to against.
No, at the instance of the Union of India, because that was in order to complete the deadline under the Right to Education Act. But all are you are in employment in 2007.
All of us, there's no question. It's the same issue. But I just want to give you the complete picture. There was a challenge in a separate batch of petitions between those who had the D.EL.ED qualification as in 2022 and those who achieved that qualification after a month or so. Both 24-month candidates, intersect between the 24-month candidate. There was an issue which was raised, which the High Court held against the people who did not have the 24-month qualification. And that has come up in an SLP. The matter has been heard and judgment has been reserved. Now, in that issue, it was dealing with the same advertisement. Different issue, same advertisement. In which this court passed an order on 29th January 2024, accommodating those from the 24-month D.EL.ED who had the qualification prior to the advertisement date. So 9,533 of those posts have been filled up from the entirety of 11,758. 750. So out of that, 2,000 balance remains. We believe that we could be accommodated against that. I just want to let you.
Who have been accommodated? Those who are having 18 months diploma or 24 months diploma?
Month was 24 months in that case. So their 24 month before date of advertisement have been accommodated 9,500. There is a small bunch who are achieved the 24 months after the date of the advertisement. The arguments I heard Mr. Gupta, I was there, it was heard, judgment has been reserved in that. So I'm going to give you the full picture. And
so should we await?
Judgment has been reserved. 24 months was 24 months. That doesn't have anything to do with
24 months. So there's no issue of 18 months there.
No, that issue is not there. Just to give you the complete picture, that's where things stand.
Not accommodate the word would be that they've been appointed. Not accommodate, because there's no concession that has been given.
That's correct.
No, they have not.
That's the
Because against us only on the issue of JV laws, because only JV laws. Now this is a that has been clarified laws. Therefore, it should be allowed. That's a short submission.
Well, the Calcutta High Court relies on JV while
Yes. Page 4.
It's only based on JV.
It's only based.
if they are in employment in 2007 on the cutoff date.
I'm accepting your lordship's orders in the reviewed order also. No question about it. But I've gone through the JV judgment also. Your lordship's recorded that batch there is a one-time
It's only for those who are the cutoff date is I think that August 2007.
Correct.
And because we are referred to the entire communication between the Union of India
Yes,
and,
Lordship,
and the
in
NIOS.
great detail, my lord, your lordship has gone through the entire process, and as I understand it, you have
And we have also held that 18 months was provided.
otherwise the 18-month course is not,
Otherwise, 18 months is not
an equivalent.
not an equivalent.
But for the purpose of those persons who were in service in
And
27.
as a matter of fact, they were sent for that course by the state governments only.
But actually, my lord, the Swayam portal was something which the state government, at least in West Bengal, had no control over. They applied themselves and they went. My lord, the consequence is a little different. I am only going to point it out to your lordship. It has, your lordship's order, my lord, is to be given effect to now. There is no question about it. The consequence is this, my lord. For instance, if I take the petitioner, SLP petitioner, Mr. Kaushik Das, he claims that he was in employment on 2017. Now, we find that he has also disclosed TED certificate at page 290 of 2022. So here is a person who under the NCT Act, under the RTE Act, section 23, would not have got employment in any institution because he didn't have TET. I'm just giving an example. So therefore, my lord, we are now a little perturbed that there may be people in this batch who have somehow got some certificate from private unaided schools. So, my lord, what we are saying is, my lord, your lordship may remand the matter back. The persons will have to be verified because there is only one appellant before your lordship in the SLP. But, my lord, when my learned friend says 300 people, then, my lord, they are coming, my lord, as my lord, leaders.
So what we'll do, we'll hold that only such of the persons who are in employment on the cutoff date,
Yes.
they would be entitled to, and that will be subject to verification by the authorities
That's
as to whether they were in employment or not.
That is whether they were validly in employment. Because, my lord, we suspect now that private schools, my lord.
So yeah, in Uttarakhand also,
Yes.
we are not directed the blanket appointment. We have said that they will be only considered, and if eligible,
Yes.
then appointed.
Yes, correct. That is one aspect which I want to bring to your lordship's attention. The second thing I wish to bring to your lordship's attention, my lord, is that as far as this process is concerned, the 2022 advertisement, 11,000 odd vacancies was there, which was advertised. My lord, 9,500 odd have been empaneled, and my lord, appointments have been given. Some 8,700 odd appointments have been given. Now, in this Somenpal case, which my learned friend referred to, where Justice Narasimha and Justice Mishra's bench has heard us out, has heard everybody out, and only written submissions are to be filed. There, my lord, it was contended by the petitioners that the rest of the seats should be for their benefit. Now, my lord, your lordship may resolve this in any way that your lordship feels, because it shouldn't be, my lord, that one steals a march over the other, etc. Then there'll be some heartburn there.
Just to respond to the TET aspect, that's a red herring that has been thrown by them. As far as TET is concerned, 2017 was the notification. They held the examination in 21 and declared the results in 22. And even the now 9,000 persons who have been appointed, your lordships, a large number of them belong to the 22 exam. So
No,
that is.
Let me explain.
So that is a red herring which they are.
No, it is not a red herring.
Of course it is.
A person may take a TET examination in 2022 and apply for future employment for the first time. But here are people who are claiming, just 1 minute. I'm not Here are people who are claiming that they got employment prior to 2017, but are showing a TET of 2022. So therefore, my lord, if that is so, my lord, then they apparently have got employment before 2027 without a TET, which would be contrary, my lord, to the legislation. So there are people like that.
No, so whether your rules require both diploma as well as TET.
Yes, my lord, it's not my rules. Now the RTE Act has made it compulsory that after a particular date, that is, my lord, 29th of July 2011, you must have both the minimum diploma qualification and a TET.
And they could have appeared for TET even without having a diploma course.
Yes. TET is an independent examination. TET is an independent examination. You have to have them separately and get it. Now, suppose today somebody takes the TET in 2022 and applies for the 2022 batch. Then there is
No, we'll only say that those persons who were in employment on that 2017 and who are otherwise qualified, they would only be considered.
Milord, one point, Milord, I'm hesitating to bring it to your Lordship's attention because it may have, Milord, your Lordship would have taken it into consideration anyway. The amendment to the RTE Act, which came in 2017, was for the benefit of people who were in employment on 31st of March 2050. And so, my lord, actually this scheme was for those persons who were in employment on 31st of March 2015, but had not been able to get the diploma, and they were, my lord, actually given an opportunity, this 18-month course. I'm just bringing it to your Lordship's attention. I do not know, my lord, whether this affects your Lordship's, my lord, orders at all. But the section says that if you are in service on 31st of March 2015, then you must get all the minimum qualifications within 4 years' time. So 31st of March 2019 becomes the cutoff date for them. And this amendment is brought in August 2017. So there was only 18 months' time to get them qualified.
But now, therefore, we have already held that.
I leave it at that.
That takes care of
May I
that.
just respond on 3 points? The first is with reference to petitioners before bylaws.
No, there is only one petitioner before your Lordship.
That's what I'm answering.
Yes.
So we will say that all such candidates who are, we will pass an order in rem, not restricting it to the petitioner, otherwise we'll be flooded with, and we'll say that the state would be entitled to consider their eligibility.
So I want to respond on that because there is something to be said. Just firstly, I think to correct Mr. Gupta, I have the SLP here. There are 388 petitioners, SLP petitioners, 388. It starts from page 7 onwards, you can peruse it. There are 388 petitioners. Now, there are many who are pro forma respondents, that's different, but I'm just saying there are 388 petitioners. Now, the point that Mr. Gupta took was that, look, you did not have a TET on the date when you were in service and you achieved this 18-month D.EL.ED qualification. You actually were ineligible to have been an in-service teacher because you lacked a TET. That's what he's saying. If I understand that argument correctly,
I've given only one anecdotal example because Mr. Kaushik Das's TET result is on record. I don't know about the others.
Mr. Gupta is not wrong. Mr. Gupta is not wrong on the fact that my TET result came in 2022. Why? Because they advertised their TET, which they had run in 2017. They didn't run TET in 2017. I applied. I was waiting. They didn't run it in 2018. They didn't run it in 2019. They didn't run it in 2020. They ran it in 2021 against the 2017 advertisement. I got the TET when you ran the TET. You gave me the result in 2022, so I'm clutching onto this in 2022. There's no other time I could have got it. That's one. Secondly, Mr. Gupta is also right that NCT regulations, which came first in August 2010, and then in July 2011, they made small amendments. Mr. Gupta is well aware that both of us are contesting this issue on mandatory nature of TET, who it applies to, etc. That is part heard before Justice Datta's bench. Now, there the question is entirely different. That's a third question which arises. And let's not conflate that with this, about whether those who are in the saddle in 2011 onwards, teachers who have been in service, all of us. Now, whether the teachers who were in the saddle in 2011 require the TET, was it absolutely mandatory? That question is at the moment sub judice. So for the state to endeavor in this case to bring this bogey up, Ms. Makhija is right, to bring this bogey up to create some confusion where you have...
Then we will have to await the outcome of that petition.
What I am suggesting is, let's not get into that for one primary reason. You'll also recall that when you dealt with the review petition, you dealt with a series of MAs. 2 of those MAs specifically dealt with Bengal. Applicants who were from Bengal came before your Lordship in this very courtroom and argued this matter. The state filed a reply, and let me show you.
But your Lordship didn't go into individual facts.
1 minute, you didn't go.
So if somebody is valid, fine, no difficulty.
The state shouldn't now be taking an additional bogey saying, I agree you were eligible to sit for the NCT 18-month course. You did the 18-month course. You qualified. The court has held you eligible to apply. But prior to you sitting for that 18-month course, your question of whether you could have continued as a teacher with or without a TET is a bogey, man. That I'm sorry. We have been in the saddle for 10 years, 20 years, 30 years. Today, after your lordship give this clarification, if your lordship were to employ the words that Mr. Gupta wants you to employ, which is to say that you should have been qualified prior to you having 18 months.
I'm not asking.
Then they will.
I'm only
ask the
saying
order,
that
tell us
subject
we
to
are
verification, that's all.
We are system only subject to verification.
Subject to verification.
And subject to
Solve this, Your Lordships.
subject to the verification.
Because the facts of each individual has not been gone into.
Subject to
Yes,
verification.
may I
Like
just-
you said,
Subject to verification as to whether they were legally appointed or not.
That's all.
that's absolutely.
Needs to be said, because this is what we are apprehending that the state will do, Your Lordships. Those who were registered for TET in 2017, because it is not my fault that I did not take the exam, they held it after 4 years. It is on their, it's their problem that they held it after 4 years. So I am registered on 2017, exam held in 2021, result declared in 2022, and the persons who are already employed and given employment to are also 2017 TET candidates.
Correct, that's
So
correct.
that should be
9,000 that they've accommodated
Yes.
includes the 2022
20,
TET.
yes.
Then they shouldn't have accommodated them. They shouldn't have appointed them.
So this should not now come up as a second point of contention and a second round of litigation, Your Lordships.
Tell
Lordships
them
may
to close them
clarify
down
that.
after this court's order directing them to appoint these 9,900. They will have to remove those people who have 2022 TET.
No, I don't have to remove because 2022 TET they have taken now.
They can't.
That's some
They
reason
can't have
I-
TET.
Future recruitments they can use the TET. But is it not my learned friend's contention that they applied for and got a job without the TET?
Of course. I was in service without TET for years. Where there was no TET.
So therefore,
TET was not a frequent stand.
I don't want to get into this because each person will have a different set of facts.
He only brought it up. You only showed
In
it.
fact, we are finding that in the present IAs, they change their stand from time
I
to time.
would suggest
First they said government
an
school
order
teachers,
similar to the
then
Uttarakhand
the
order,
private.
my lords, where let them verify and just confirm. That's all.
That is what he is also saying.
Facts and
We will not go into the date issue.
in fact, my lord, if I may just add one more thing, my lord, my learned friend has shown your lordship one order of the Calcutta High Court, recent order, which relies on your lordship's my lord review order. There, my lord, that particular individual was before the court, and her my lord qualifications had actually been checked, and a report had been given by the director that this is all right.
So therefore, we will say that the subject to verification, eligibility and
But registered in TET.
no.
No.
Then we will await the decision of the.
Huge problem.
We will await the decision of the other way. No, here the advertisement is what is the rate of advertisement?
29 September 22.
22. And the TET results were declared on 10th January 22.
No, that is not relevant for the.
Anyway, we are not going into date now. We are only going into as to whether you were appointed on a cut-off date, as to whether you were and the verification regarding your eligibility and the regular employment. Because we don't want to open a floodgate as get some fake certificate and all that.
Obviously, we will not defend the fraud, my lords.
In this state itself, my lord, we have had a situation where once an order was passed by this honorable court in 2011, my lord, hundreds and hundreds of people started coming, filing affidavits saying that I was also qualified on 20. Here also, my lord, multiple implement applications.
How many petitions are there? No, total petitions.
There are
SLPs.
Yeah,
So, Lordship, I say
SSLP, there is one.
one SLP in which there are many intervention applications.
Yes.
There are many 100 intervention applications are there.
We'll dispose of all interviews.
Yes, yes, yes.
Close for orders.
Great.
वो draft बना के दे देना.
Hope you won't see us again.
That we don't know.
Millard, I hope, Millard, your lordship will see us, but
Yeah.
not in
Not in this
matter.
matter.
Spend on Mr. Gupta's clients. Grateful, Your Lordship.
Yep, yep.
Mr. Gupta, you are happy to go home. You are already appointed. We are not going to disturb them. Good for you. It will take care of his today's.
This is only 43.1. 43 will have to come on another date. That's for Bihar and UP. There's some other date because the government is yet to respond on 43.
ठीक है 43 के बाद में कर
Any other date. Wait for the deeply.